afternoon and happy Friday. Daniel Bornstein with Bornstein Law and Bay Property Group. As many of you know, I've been practicing law for over 30 years. I'm also a broker with a property management company and also handle expert witness assignments when involved with landlord-tenant disputes and the impact rent control and just cause eviction rules have on tenant disputes. Today, however, please strap yourself in, congratulate yourself for making the decision to learn and understand what we are faced with as we trend into 2025. This is not an exhaustive list of new laws, but it is intended to familiarize you with the new laws that are coming into effect and also some of the post-election impact that rental housing providers, real estate investors, and all of those who are interested may need to know in order to effectively handle your real estate investments, and or if you're a tenant, simply to understand what is available and what is not available and what the rules are for that. So we have a lot to cover, and the whole goal would be to help you familiarize yourself with what's happening throughout California and in some of the local jurisdictions that we have in and around the Bay Area. So with that stated, again, I'm Daniel Bornstein. Let's get started. Let's look first at the federal level. Very important, though this isn't particularly germane to real estate, it covers many, many different aspects. But if you are a member of a limited liability corporation, a C Corp or an S Corp, if you employ fewer than 20 employees or receive under $5 million in cash receipts, you now have a disclosure obligation to the federal jurisdiction. And what you need to recognize is the whole goal is to uncover and be more transparent and who has a relationship with one of these entities. So be advised, there are huge, huge financial consequences for not registering and not reporting. You must register by January 1st, 2025. For most of my clients who are limited liability company members or managing members or C Corps or S Corps, you've got to now report. It's the Corporate Transparency Act, and it is now going to be a requirement, and you must register by January 1st, 2025. This is a new law, and everyone who is involved in one of these entities is likely and must disclose their relationship to the entity, and registration is due January 1st, 2025. Effective February 1st, 2025, Freddie Mac rolls out a new policy framework requiring minimum lease standards for multi-unit properties where we have an enterprise-backed loan. The key provisions, which I don't find them to be difficult, problematic, are as follows. 30-day notice of rent increases. Well, we know in California, if you're going to raise the rent over 10%, it's on 90 days notice. So these provisions hardly have much impact. Under 10% is 30 days notice. You must give a 30-day notice of a lease expiration. And also, there's a 5-day grace period for late rent payments. Tenants will have 5 calendar days from the rent due before any late fees or penalties can be charged. This only applies to those multifamily properties where we have enterprise-backed loans. If you don't know whether you have an enterprise-backed loan, contact your loan provider. California. California has a litany of new laws. Many of them have significant impact on the day-to-day operation of our real estate investments. Let's go through them. As many of you know, I handle hundreds of unlawful detainer actions throughout the Bay Area each year. An unlawful detainer action is a trade name for what we generally understand to be an eviction action. We now, starting in January, have an elongated period of time before a defendant has to file an answer to an eviction lawsuit. So instead of it being 5 court days, it's now 10 days. So if I serve a lawsuit on a tenant in November of 2024, they have 5 court days, not weekends, to respond to the lawsuit. Now it will be 10 court days. While many of you may say, well, what's the difference between 5 or 10? I will tell you that this will mean that evictions will take longer to accomplish. And when it takes longer to recover possession of your unit through an eviction lawsuit, you will likely lose more money in uncollected rent. Anytime there's a delay in the unlawful detainer action, it serves the benefit of the tenant. It's very hard to recoup or recover unpaid rent debt. And so while it looks like it's only a 5-day difference, it can be a difference in thousands of dollars of unpaid rent, because it's not just 5 days, it's 5 court days. Now it's double to 2 weeks. So half a month of rent is likely to be increased in loss, because when you consider the 5 court days plus the weekends, you're simply getting a delay in the process of recovering possession of the unit. This is going to make it more expensive, more painful for people who are seeking to recover possession of a unit through use of the court system. Rental applications and screening fees. A new law. You must provide a tenant a furnished copy of their consumer credit report within 7 days of actually using or securing the report. And another important point, the first applicant who meets the tenant screening criteria must be selected. That doesn't mean the first applicant who has satisfied your credit report standards. It means the criteria you let and articulate for purposes of having someone qualify for a unit. Good landlord references, good professional references, good personal references, meets your credit standard. That first applicant is the one you must select. Many of you know that last year I introduced the new law regarding balcony inspections, and there's a whole new burgeoning industry of people who are serving this aspect of inspections. Luckily, this deadline has been extended from January 1st to January 1st, 2026. We do recommend you get your balconies inspected. Do it sooner than later, because once we get closer to that extended date, these contractors, these inspectors are going to be full and very busy. So I would recommend you be proactive and get these inspections done. A new administrative responsibility. We have a goal of allowing tenants to boost their credit scores by allowing credit reporting companies to take information about their timely rent payment. And effective April 1st, 2025, tenants occupying buildings with 15 or more units will have the option of having a timely rent payment noted on their credit report. Landlords now must notify the tenant of this capability at the inception of the tenancy and extend this offer at least once annually moving forward. Tenants who avail this opportunity, they can opt out but they cannot opt back in for at least 6 months. What does this mean? You have now, if you own a building with 15 or more units, you now have a new administrative responsibility of notification. And the assumption is that every time you have a new administrative responsibility, there are going to be owners, rental housing providers who forget or are unaware of this law and create liability for themselves by not offering this option. My expectation is that leases will soon include this notification, or we will have an addendum for those buildings that are 15 units or more to provide it. And if you are using an old lease from 2005, of course, you're not going to have this, which is an important point. You got to keep getting updated leases on a yearly basis so that you are in tune and in step with all the new laws. We always look at the lease agreement, see when it was copywritten to make sure we're using a industry accepted lease agreement. So if you're in San Francisco, the Small Property Owners Association lease, the San Francisco Apartment Association lease, if you're in California, the California Apartment Association lease, these trade organizations will integrate new laws and add them into the lease so that you are protected. New law regarding security deposits. Last year, we introduced new rules regarding how much you could charge for a security deposit. That was effective July 1st of 2024. Well, we have a new security deposit. Get out your cameras. You will now have an obligation to take photographic documentation of your rental unit at the inception of the tenancy, right before a tenant moves in, at the end of the tenancy, and before and after repairs, cleaning, or renovation required is done. So get yourself a good digital camera if you don't have a smartphone. I always recommend photographic documentation in anticipation of a tenant dispute with security deposits, but now you have an affirmative obligation to do so, which means when you get to small claims court after the turn of the year and you don't have the photographic documentation evidencing the condition of the unit at the inception of the tenancy, when the tenant moved out, and after you have effectuated the cleaning, you're going to lose that security deposit dispute in small claims court because you didn't comply with the law. How many people are not complying with the law? Many, many people. The beauty of today is to be familiarizing yourself with new laws that are coming into effect so you insulate yourself from the ignorance of simply not understanding that the laws change. And as we can expect in California, the laws typically change to make it more burdensome, more onerous on housing providers. The public policy behind this is we want you to have evidence and documentation before you start taking deposits and deducting for damage done above reasonable wear and tear. And the best documentation is a digitized video and photos. Remember, a picture speaks 1,000 words, and your best defense against a claim that you have overcharged a tenant for a security deposit deduction is to have the documentation in place, invoices and photos of that damage. I'm not disappointed by this law. I think it's good practice nonetheless. And what this law does is document what we believe is appropriate, so you're prepared if you ever have a security deposit dispute with your departing tenant. Let's move on. A new law regarding domestic violence. There's a lot of rules regarding domestic violence, and the most important thing at this point in time is that you recognize if someone's a victim of domestic violence, you always want to be very careful what you do, because there are different rules and obligations in California. And the most important thing is that if someone asserts that they're a victim of domestic violence and you don't know what the rules are, you contact my office or contact an attorney. But effective January 1st, for all tenancies that have commenced after January 1st, 2011, you need to know that if someone is a victim of domestic violence, they are entitled to expect that you are to change their locks, and it will be at the landlord's expense, not the tenant's expense. The abused tenant need not provide a police report or a court order. Statements from a qualified third party will suffice. Most importantly, when faced with a situation involving domestic violence, contact my office. Many of the issues depend upon if the abuser is within the unit, if the abuser is coming out and lives somewhere else, or whether the victim seeks to have alternative housing in some situations. And now we have this added one where, look, if someone's a victim of domestic abuse and their lease commenced after 2011, which is probably the vast majority of people at this point in time, they're entitled to a lock change at the landlord's expense. All right. Proposition 33. The real estate community spent in excess of $100 million to defeat Proposition 33. Proposition 33 was Michael Weinstein's attempt to repeal Costa-Hawkins. The proposition failed. We shall all celebrate and congratulate ourselves for having successfully defeated Proposition 33. San Francisco, in anticipation of Proposition 33 passing, enlarged rent control. But since Proposition 33 failed, that new proposed law has no impact. Costa-Hawkins, remember, typically allows single-family homes, condominiums, and newly constructed buildings to be free from rent regulation. There are caveats, there are exceptions, but generally, you know, single-family homes and condominium units are typically not subject to rent control. That remains the same because Prop 33 failed. Also, Costa-Hawkins allows where an unapproved occupant remains in a unit where the master tenant has vacated, you can raise the rent to market rate. This is crucial, and part of much of my work as an attorney is that cat and mouse game of trying to ensure that you have the ability to raise the rent when you have a vacancy or when you have a master tenant who has vacated the premises. This is important, and this is so key to the success of our real estate community throughout California. Proposition 33 was especially dangerous, and we can be thrilled that in fact it was defeated. Prop 34. Prop 34 was an attempt to ensure that organizations that, for instance, Michael Weinstein was involved with are using their funds to serve their community as opposed to pursuing state statutes that end up impacting others. So Proposition 34 passed. The hope is that this will dissuade a gentleman like Mr. Weinstein from pursuing another attempt to repeal Costa-Hawkins. Rest assured, Prop 34 is likely subject to additional litigation, but for now it has passed, which may put a damper on any other future attempt to use a proposition to repeal Costa-Hawkins. However, I have just read on my BART ride to my office, nothing prevents the legislature from changing the laws as relates to rent control, just cause eviction rules in Costa-Hawkins. So we are still a work in progress, and the presumption is that change is likely, You just need to stay informed of how laws change. We now know, of course, that we have state rent regulation. We have state just cause eviction rules. We have local jurisdictions that have more strict rent control, more strict just cause evictions. And we continue in California to face the burden of overregulation of this industry. San Francisco. Well, the elections about a week ago, a little more than a week ago, heralded some new faces. We have, I think, a more centrist politician who will assume the mayor position. And we also have what I consider to be the good news of the displacement of Dean Preston from District 5. Dean Preston lost. If you may know Dean Preston's history, he was an attorney with the Tenderloin Housing Clinic, became a politician, and pursued some of the same tenant-friendly legislation that consistently creates havoc among those people who are housing providers in San Francisco. So I'm particularly pleased that we have a new supervisor who will replace Dean Preston. And my hope is that we have a reset on how housing providers are treated in San Francisco. Generally, the election resulted in a more centrist political orientation in San Francisco. And the hope is that we will have a better and more prudent treatment of some of the issues like crime, homelessness, drug use. We have a better approach from a public policy standpoint with a more centrist and moderating political leadership. Another bit of good news. So we have Prop 33 statewide failing. We have Prop 34 passing. We have Dean Preston losing his supervisor position. We have a new mayor. And we also have an important ruling in the court. The vacancy tax, as it was called, was struck down in the court. For the last 4 months, I've been getting calls from people very concerned about whether they're going to be taxed on a unit they own in San Francisco that's not being rented. It did not apply to single family homes or duplexes, but those people who have multi-unit properties that have decided to keep some of the units vacant were going to be subject to a punitive tax. Luckily, the court found the tax to be inappropriate and struck down the law. That's great news. However, the city is expected to appeal. Right now, the tax is invalidated, but it remains to be seen how an appellate court will treat the ruling that was issued in the San Francisco court. I'm pleased because I had a lot of people calling me about, hey, can I rent the unit out to my brother for $10 a month? Would that solve the problem? And people were getting very, very creative about how not to have a vacancy. And I did not have good solutions because the law was written in a way that you had to have a bona fide tenant. You couldn't create a bogus lease for the sake of claiming that your unit was occupied. Most importantly, however, for now, the law was struck down. I don't think it's constitutional. If you buy a bike, you can look at it, put it in your garage, never use it. It's your property. It's your decision whether you want to use it, lend it out, or not. Similarly, I believe that if you have a rental property or a multi-unit property, you can keep it vacant, you can go and use it yourself, or you can rent it out. That's your prerogative. The state, the city should not require you to rent something out if it's yours. You have the decision to do so as a private property owner. So I hope that the appellate court rejects the law again and that this by next year is no longer something that we are concerned about in and about San Francisco. San Francisco, if many of you know, there was a software program that was providing data about rent prices that were being used by different housing providers in order to best approximate what would be market rate for a property. Interestingly, there was a claim of price fixing, and this new ordinance bans the sale or use of revenue management software that allows landlords to indirectly coordinate with one another using non-public data. I just got a reach out from the Pacific Legal Foundation because they're interested in learning more or maybe even attacking this law, because why would rent information be something that one could not learn about? We don't believe this is a price fixing scheme. It's merely a mechanism and an instrument to assess what is market rate for properties. Most importantly, however, right now there's a law precluding it. And at this point, you are not to use any of these type of software packages that are available or were available, because you would then be in contravention of the law. This may be challenged. We shall see. Alameda County. I used to say that San Francisco was the most difficult of the rent ordinances. Berkeley, of course, had a reasonable right to claim the most pernicious rent ordinance. But over time, I'm starting to believe that Oakland is one of the most difficult rent ordinances throughout the state. And Alameda surprises me with its progressive movement that I think is in conflict with good policy. Nevertheless, despite my discussion and a little bit of my soliloquy, the most important thing for you folks is to at least be aware of the laws that are forthcoming. Let's look at it. Oakland. So, Councilmember Dan Kalb has always been very progressive and very tenant friendly. He has just issued proposals to change rules and laws that would prohibit rent increases and evictions if a landlord is more than 60 days delinquent on business taxes. Shocking. What if a landlord is 60-day delinquent on business taxes because his tenant hasn't paid rent for 18 months? That isn't part of the proposal, of course. There would be fees imposed if a landlord is 60 days delinquent on business taxes. It would eliminate banked rent increases when a property sells. Oftentimes, when someone's making an investment decision on a multi-unit property in Oakland, they're assessing what type of increases they would be permitted to impose based upon banked rents. So now you would not be able to inherit a below market unit and bring that unit back to rent that is at least tolerable, because you would not be entitled to the bank rent. And they would limit bank renting to 4 or 5 years. So you couldn't go back more than 4 or 5 years, despite a landlord may have not raised rents for 10 years. And then you would have to provide notification to the tenants of these changes. Remember, this is not law right now, it's a proposal. But the reason I present this to you is because you can get a sense of some of the pernicious aspects of what's happening in Oakland that don't make sense, that are bad public policy, but are still being discussed, debated, and maybe integrated into a revised ordinance. Be advised, on November 19th, the committee will discuss these proposals. For those of you who are Oakland multi-unit investors for housing, please attend the committee meeting and let me know what transpires. I will certainly do my best to let our community know what it looks like and whether these proposals get out of the committee. Berkeley. Berkeley's election had two competing measures, and unfortunately, Measure BB, also called the Berkeley Tenant Protection and Rights to Organize Act, has passed. Rent increases are now limited for regulated units to 5%. While that's painful, it's typically a moot point because yearly increases in Berkeley under the ordinance have always been less. Tenants now have the right to organize tenants' unions and negotiate as a union. And if you do not negotiate with the tenants in good faith, you could face a consequence on an impact on your rent due to your failure to negotiate. San Francisco has this already, and now it's coming to Berkeley. Like Oakland, they are now limiting when you can demand rent based upon a 3-day notice, because now you can only demand rent in Berkeley for covered units when the debt amount is over a certain limit. Pre this measure, if a tenant owed you $500 in unpaid rent, you could serve a 3-day notice to pay rent or quit. Now you're going to have to know what the fair market value for that unit is and wait until that debt goes in excess of that before you can serve a 3-day notice. What this means is you'll have to wait until the debt is large enough. Now in 2025, we're going to have a 10-day service of an eviction action. So in Berkeley, you're going to even lose more money going forward with non-payment of rent evictions than you did pre-2025. They're going to put strictures on breach of lease to make sure that the breach is substantially harming to the owner. Generally, if someone breaches a lease agreement, it doesn't matter whether it's substantial or not, you can proceed with an eviction action in California. Here, though, it must be directly and substantially harmful to the owner. RUBS, which is a ratio utility billing service, will be impacted for leases signed after February 6, 2024. Ratio utility billing service is where you have a master metered utility service and you try to divide it into an approximation or a ratio, and you impose it upon different tenants based upon a different metric. Rest assured, in Oakland, for covered units, it's not permitted. And in Berkeley now, we're going to have more stringent prohibitions against it. And now there's an additional requirement for owners to file eviction notices and legal complaints with the rent board within 3 days instead of 10 days. I will tell you, to keep track of all the changes in the law is a big, big task. My office has offices in Oakland and in San Francisco. We serve Marin County, San Francisco, San Mateo, Alameda, and Contra Costa. It's enough to try to stay informed with all the different communities throughout these different counties. Berkeley, this new measure adds an additional set of requirements that we now need to be familiar with. Antioch. Antioch used to be a bastion of conservatism. Now Antioch has a more stringent just cause eviction protections. There are now relocation payments. There's a 120-day notice provision. There are relocation payments. There are now documented tenant buyout requirements. We know about tenant buyout agreements. We know that in Berkeley, Oakland, San Francisco, there are protocols you have to follow. Well, now in Antioch, there are protocols you must follow as well. And of course, there's a provision that landlords are not entitled to retaliate against their tenants. I bring this to your attention not because many of you have rental property in Antioch. I bring this to your attention because you can see that over time, more and more local jurisdictions are advocating policies on behalf of tenants that make it more difficult for housing providers to handle their investments in a way that's free from city or county engagement You must be informed of the law. I can only tell you that most of my clients are lovely people. They have wonderful character, but they make mistakes, not because they're intentionally trying to harm someone, but simply they don't know the law and they get shocked that the law is in place. There are so many times when I have to explain to a client, just because your lease says you can give a 30-day notice to terminate a tenancy doesn't mean you have the right to do so if you don't have a just cause under the San Francisco ordinance or the Oakland ordinance or the Berkeley ordinance or now the Antioch ordinance. Many people read the lease and say, I'm going to serve a 30-day notice. I want to sell the property vacant. And they don't realize that selling a property vacant is not a just cause under the most of the local ordinances. And even if you own a multi-unit property in California, you've got to be careful. Does the desire to sell a vacant building in Walnut Creek, that's a 5-unit building vacant, is not a just cause to evict under the state ordinance. I can tell you that I'm familiar with the law. I don't know that there are many people in the industry that are familiar with all the different laws. When in doubt, reach out to me. It's my pleasure to educate people, and it's my pleasure to keep you out of trouble. And usually a quick email and a quick phone call will get you into a position where you're not making the mistakes that many people do. And remember, there are brilliant tenant attorneys looking for you to make a mistake so that they can sue you and thereafter send their children to private school. And because the ordinances are so difficult and have such large penalties for mistakes, you can face a terrible financial consequence if you are engaged in behavior that's in conflict with the law. The courts. Ever since COVID, the courts have struggled. We have budgetary crisis, and we also have delays. We have difficulty in getting to courtrooms. We have difficulties in even having settlement judges hear our settlement cases. Pre-COVID, there was always judges who would handle San Francisco settlement conferences for eviction actions. Now, sometimes you have a judge. Sometimes they tell you to go outside and try to resolve the matter yourself. And I can only tell you that if you can avoid the court, do so. If you can reach an agreement with your tenant, do so. Whether it's a buyout agreement, whether it's a compromise, reach an agreement and avoid the court so you don't bleed attorney fees. You don't get involved in litigation, and it's your last choice, not your first choice. As I told you before, starting January 1st, we're going to have a delay in the eviction process because tenants will have more time to file a response. This is going to make things slower. I can't tell you how many times I have clients push me and let me know how frustrated they are that the lawsuit started in October and it's now November and they don't have closure. And I have to tell clients an eviction action from the time the lawsuit starts is usually a 90-day process, 3 months. And remember, once you file the lawsuit, you can't collect the rent. If you collect the rent during the eviction process, you reinstituted the tenancy. You lose your case. And every year I have a couple clients forget that, collect the rent, tell me they collected the rent, and then I have to tell them we have to dismiss the case and start over. When in doubt, always talk to your attorney, especially if a lawsuit's been filed. If you're contemplating a lawsuit and there's a compromise that can avoid it, please consider it. My goal, whenever anybody talks to me and says, Daniel, I'm going to file a lawsuit, I'd like to hire you, I always say, the goal is to recover possession of the unit as fast and as cheap as possible, taking into account attorney fees, time, and risk. That's all I'm about. Your real estate is valuable. The cash flow is important. And all I'm trying to do is accomplish recovery of your cash flow by putting in a better tenant who is more likely to pay the rent on time than the current individual who is posing problems for you. I always end by, as I tell you, make sure if you can avoid a dispute, you can do so. My office is handling tenant buyout agreements throughout the Bay Area. And generally, depending upon the jurisdiction, there's about 8 pieces of information I need in order to prepare the buyout agreement. The name of the owner, the name of the tenants, the address of the unit, when the tenant is vacating the unit, how much are you paying them? When are you going to pay them? Are the tenants going to continue to pay the rent? And are you returning the security deposit, or is the tenant forfeiting the security deposit? With that information, I can prepare a buyout agreement. I want to caution you though, if you're in Alameda, the city of Alameda, if you're in Richmond, if you're in Berkeley, if you're in San Francisco, if you're in Oakland, if you're in Antioch, there are certain rules that regulate buyout agreements, so you need to know the rules. But I will tell you, if a tenant hasn't paid you for 2 months of rent, and you have the right to go forward with an eviction action that's going to take you 3 months through the court. If the tenant says to you, I'll leave in 30 days, just waive 3 months of rent, what do you think I'm going to tell you? Do it. Don't go to court. Let's negotiate a deal. Not only do we want the tenant to voluntarily move out, we want them to waive all claims arising out of their tenancy, including those claims they don't know about. So you want to have a proper buyout agreement. And I'm happy to help you out. I'm helping people handle buyout agreements all the time. We're very busy. It's my preference to avoid court and get to an agreement. Sometimes you can, sometimes you can't. Most importantly, it's part of an array of options that you consider when evaluating either the sale of your property, a tenant existing dispute, the purchase of a property, or simply you've got a problem with the tenant who's engaged in nuisance conduct, and the path of least resistance is to seek a voluntary move out. Rest assured, I'm here to help you out. For those of you who are frustrated with the management of their rental properties, I have a brokerage, Bay Property Group. We are happy to consider management of your investments. For some people who have been wedded to their property and haven't had that transition time to enjoy life because they are constantly dealing with their rental property, there are solutions. For those of you who have an existing dispute, there are solutions. For those of you who are considering a purchase of a property, a half-hour meeting with me will help you make a good decision about that investment. If you're preparing a property for sale, a half-hour meeting with me can help you think strategically about how to best position the property for sale. I'm a business person who inhabits the world of landlord-tenant law, and my hope is that we all make good business decisions about your real estate. And again, you should be congratulating yourself for coming and learning today, because one way to be good about your business is to know what the laws are, to know what the shifting political stance is, and to be ready for 2025, knowing that there are good new laws and some more stringent laws that you're going to need to be familiar with so you don't create liability for yourself. So with that, I want to thank you very much. I want to let you know, if you have a question, email me. If I need to have a meeting, I'll let you know. I am sending out e-blasts on a weekly or bi-weekly basis, educating people about the law. I have a wonderful team of people dedicated to helping build knowledge. And if you aren't on that list, please consider it. I'm going to upload this webinar to YouTube. I'm also going to send an e-blast out, distribute it to others who are similarly situated. I always take pleasure in knowing that people are being educated so they don't make the mistakes that I hear on a daily basis when people call me up and say, Daniel, I've been sued. So with that stated, I want to thank you. I want to let you know that it's my pleasure to be here, and I am so excited about the holiday season and hope all of you have a wonderful Thanksgiving as we're getting closer to that date, and also enjoy December and all of those other holidays. And I hope to hear from you, but only good news, not bad. Thank you very much. Daniel Bornstein, Bornstein Law and Bay Property Group.